Contract and elements of contract, class 11 business study. So now let us see what is a contract. According to law, the law relating to contract is governed by Indian Contract Act of 1872. As per section 2H of the Indian Contract Act 1872, contract means an agreement which is enforceable by law. For example, is marriage a contract? In India, marriage is not a contract. The people of India treat the marriage as a religious bond between the couple. Now, let us look into the essential elements of a valid contract. Section 10 of the Indian Contract Act says, all agreements are contracts if it includes the following essential elements. Number 1, offer and acceptance. Then, intention to create a legal relationship. Number 3, lawful consideration and object. Number 4, capacity to contract. Number 5, there should be free consent. Number 6, there should be a lawful objective. Number 7, agreement and expressly declared void. Any agreement that is not expressly declared void is a contract. Consensus ad idem. That means meaning or meeting of minds. Two people should come together to enter into a contract. Certainty of meaning. Possibility, there should be possibility to perform the contract. Then last comes the legal formalities to be considered while signing a contract. Now, essentials of a valid contract. What is a valid contract? There are two important things for a valid contract. Plurality of persons. There must be two or more persons to make an agreement because one person cannot enter into an agreement with himself. Consensus ad idem. The meeting of the minds is called consensus ad idem. It means both the parties to an agreement must agree about the subject matter of the agreement in the same sense and at the same time. What is an agreement? As per section 2E of the Indian Contract Act, every promise and every set of promise forming the consideration for each other is an agreement. Is agreement a contract? An agreement to become a contract must give rise to a legal obligation. If an agreement is incapable to be enforced by law, it remains only agreement and not a contract. Like for example, the Indian Contract Act has defined contract as an agreement which is enforceable by law. So now, what is a social agreement? Agreement of a social or domestic nature do not contemplate legal relationship. As such, it is not a contract. Agreement without legal intention. The second essential element of a valid contract is there must be an intention among the parties that the agreement should be attached by legal consequences and create legal obligation. If there is no such intention on the part of the parties, there is no such contract between them, because in case of any dispute or breach of contract, the agreed party should be able to go to the court of law for getting justice. So that means agreement without legal intention is not a contract. Agreement without consideration. The third essential element of a valid contract is consideration. Consideration means something in return. Quid pro quo. Consideration is an essential component of a valid contract. Consideration is the price for the contract. Agreement without consideration for any social obligation or due to any friendship is not a valid contract. Why is an agreement void? A void agreement is one which is destitute of all legal effects. It cannot be enforced and confers no rights on either party. It is void and initio, not exist in the eyes of law. For example, an agreement without consideration is void, or any social agreement is void. Agreement between two friends is void. When is a contract void? A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. For example, due to throat cancer, a singer refused to sing for a musical concert for which he has agreed before 6 months without knowing his disease. So, the only remedy is here, whatever is advanced can be restored. Whatever amount they have given as advance can be restored from the singer. And the contract becomes void. What is a contract of indemnity? A contract of indemnity is a contract by which one party promises to save the other person from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. The person who promises to indemnify or make good the loss is called the indemnifier, and the person whose loss is made good is called indemnified or the indemnity holder. For example, the contract of insurance is an example of contract of indemnity. In consideration of premium, the insurer promises to make good the loss suffered by the assured on account of the destruction by fire of his property insured against him. This is an example of fire insurance. Essentials of indemnity. The promisee in a contract of indemnity acting within the scope of this authority is called is entitled to recover from the promiser. So what is he entitled to recover from the promiser? All damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. As per the context, all damages as per the contract should be compensated by the indemnifier. Now, all costs which he may be compelled to pay in any such suit if in bringing or defending himself. For example, if there is a dispute in the contract of indemnity and if the indemnified and if the promisee suffers a loss, then the loss has to be compensated by the promiser. All sums which he may have paid under the terms and any compromise of any such suit. Thank you. For detailed notes and question and answers, log on to EDUGURU-Notes.blogspot.com.